What is the difference between force majeure and the doctrine of frustration? That is perhaps one of the most commonly asked legal questions, especially in difficult times like this. Or perhaps, another commonly asked legal question is, am I required to continue with my contractual obligation under the current abnormal circumstances? In contract law, clauses on force majeure and the doctrine of frustration can shed some light as to how one should respond when there is a change of circumstances. Force majeure is defined as an event that could or could not be anticipated and is beyond a person's control that prevents or interrupts him from fulfilling his contract. Now, in countries that have civil law jurisdictions such as Germany, Italy, and China, force majeure is a concept that is recognized in their local laws, whereas countries that have common law jurisdictions such as the UK, Australia, and Malaysia, which is where these videos are made and where the discussion of law will be premised on, force majeure will only apply if it is provided for in your contract. For common law jurisdiction, in order to rely on force majeure clauses, one must provide an exclusive list of events that will be considered as an event of force majeure, such as fire caused by third parties, flood, riot, an act of God, and so on. For example, if the supply of a particular good was prevented as a result of the effects of the coronavirus, the force majeure clause will only apply if the parties have included pandemic or epidemic as part of the exclusive list of events that is considered as force majeure. To a certain extent, force majeure events are events that the parties must have foreseen that it could or could not have happened. When the force majeure event does happen, it either relieves the parties from performing all or part of their contractual obligations or deferring their contractual obligation as well. What happens then if the change of circumstances is not part of the force majeure event? Or is lost? Not necessary. It depends. Frustration is defined as a supervening event that happened after the execution of a contract, which is beyond the control of the parties, that renders the performance of the contract impossible or unlawful. The reason it has to be an event that happens after the contract was signed is because there must be a change of circumstances and that the event was entirely not foreseeable at all. For example, like the 1997 film Volcano starring Tommy Lee Jones, a volcano suddenly erupts in the middle of Los Angeles, which paralyzes all businesses nearby. This is an entirely unforeseeable circumstances. Perhaps some of you might probably want to start incorporating clauses on volcanoes after watching this video. In any event, if this is not stipulated in the contract, it will be regarded as a frustration, especially to one who is contracted to supply cupcakes on a weekly basis to a cafe that is completely destroyed by the hot lava and the ash clouds it emits. The contract is then void and all subsequent contractual obligation will then cease. The doctrine of frustration is defined in Section 57 sub 2 of the Contract Act 1950 in Malaysia. Now that you know the difference between force majeure and the doctrine of frustration, which do you think applies to your current situation? Or more importantly, do you think terminating a contract is inevitable in your current situation?